give it just a couple more seconds. Our live stream is getting started. And I'll give you an okay when it's up. Okay, Emily, we are good to go when you are.
Thank you so much, Greg. Good evening. I want to welcome you to the Governor's Task Force for Racial Equity in Criminal Justice Learning Series number 5. This is our 5th in this series of events. And tonight we are going to be discussing embracing inclusive juries, focusing in on the task force recommendations pertaining to jury reform. And before we get the discussion underway, I want to recognize and invite one of the leaders of the task force. As you all know, this task force is co-led by co-chairs Attorney General Josh Stein and North Carolina Supreme Court Associate Justice Anita Earls. Justice Earls is with us tonight, and she would like to make some opening remarks welcoming you all to this event. So Justice Earls, thank you so much for being with us tonight. The floor is yours.
Well, thank you so much, Emily. And I want to just welcome you on behalf of my co-chair, Attorney General Josh Stein. I want to welcome all of you who are joining us, or who are watching this. And I especially want to thank our panelists. I'm really looking forward to the information they will share. I just wanted to set the stage a little bit, just to say that as a voting rights attorney, I see jury service as a really important element of civic engagement, and an important way that people participate in government. And so while Batson, I think we often you can be focused on the right of a defendant to have a jury of their peers and to have a jury selected without the taint of racial discrimination. I just want to throw in there the additional concept that it impacts all of us when people are excluded from juries based on their race or other characteristics that don't have any impact on their ability to hear a case and make a decision. And I think that it impacts not only the individual juror who is wrongly excluded from jury service, but everyone in the courtroom who sees that a person of color or a woman or some other individual is being excluded from the jury. There's no explanation particularly when in a situation where multiple African Americans are excluded from a jury. Everyone in the courtroom gets the message that for some reason they're not qualified, they're not worthy to sit in judgment of their fellow citizens. And that's just completely the wrong message to send. And so I feel really strongly that it is so important that we address this issue, both for the criminal and the civil justice system. And I am so grateful that we have with us tonight some people who are going to give us a lot of guidance and wisdom on how best to do that. So with that, I will just thank you all for being here and look forward to tonight's program.
Thank you so much, Justice Earls. I'm going to go ahead and share my screen. And while I do that, I want to invite you to put comments or resources in the chat and questions in the Q&A. We have a long amount of time at the end of this program. This program can go up until 7:30 this evening, 4:30 for those of you joining us from the West Coast. So if you don't get your question answered in the first segment of this program, rest assured we're going to get to as many questions as we can in the final segment that we are reserving for Q&A. And I would also like to invite you, if you're joining us from wherever you're joining us from, to just put your name and where you're joining us from in the chat if you'd like to, so that we get a sense of who's participating tonight. So before I bring our distinguished panelists into the conversation tonight, I'd first like to ask, I appreciate that our panelists have their video on. Let's have everyone who's not speaking mute, just to make sure that we have decent audio quality tonight. and I'm going to give a brief introductory presentation to set the stage and provide some context for tonight's discussion. Somebody give me a thumbs up if you can see my slides, please. Awesome, thank you so much. Okay, so any discussion of juror discrimination and jury reform in North Carolina, I believe, needs to begin with a recognition of, I'm sorry, I just lost the ability to share my screen, so let me try that again. Beginning. Let's try that again. Needs to begin with a recognition of the very ugly history of racial exclusion from jury service in North Carolina. In the case of State versus Marcus Robinson, this is one of the Racial Justice Act cases decided last year. The majority of the North Carolina State Supreme Court said that the same racially oppressive beliefs that fueled segregation manifested themselves through public lynchings, the disproportionate application of the death penalty against African-American defendants, and the exclusion of African-Americans from juries. So as I believe everyone joining us tonight is aware, the long-standing legacy of racial discrimination in jury selection and in jury formation is very well documented, both nationally and in North Carolina. And it seems that in many respects, our existing legal framework has proven incapable of addressing the problem. And so recognizing the failures of the Batson framework in particular, and also some difficulties guaranteeing the promise of the fair cross-section right, states around the country have begun to adopt or look at adopting reforms meant to ensure the promise of inclusive representative juries. And so we've seen that really develop into a nationwide movement. And this modern movement really first out the gate was Washington State that adopted General Rule, the state Supreme Court adopted General Rule 37, applying applicable to both civil and criminal trials, which is really a wholesale replacement of the Batson standard with a much more searching and nuanced approach to considering whether or not race or another improper factor has influenced a peremptory strike of a potential juror. We've also seen reforms similar to that in California. Arizona most recently abolished peremptory strikes, and many other states are looking at adopting jury reforms. Professor Liz Semmel at Berkeley, who I believe is joining us tonight, helpfully has created a database, and I'm going to ask Greg if you can put a link to that in the chat that allows you to see where jury reform is underway or has already been adopted around the country. So North Carolina is one of many states that is taking a close look at how we can strengthen the guarantee of a fair and impartial jury and really make sure that we are, making good on the constitutional guarantee of a jury of one's peers. So what are the task force recommendations as they pertain to jury reform? Well, really, there's 4 recommendations that focus on these issues. The first one, recommendation 91, and Greg, if you could put a link to the task force report in the chat, is really around fair cross-section issues and the ability to access more jury data to determine whether or not our jury pools and our seated juries are inclusive, representative, and diverse. Batson reforms similar to General Rule 37 in Washington, strengthening the legal standard offering protection against discriminatory peremptory strikes. The Washington standard and many of the key elements of GR 37 are specifically mentioned in the task force recommendation. Recommendation 93 addresses implicit bias, juror implicit bias, as well as the importance of implicit bias education for all court system actors that interact with the jury or the formation of jury lists, any element of the jury process in North Carolina. And then the final recommendation goes on to recommend establishing a body to consider more comprehensive jury reform in North Carolina, going even beyond those recommendations mentioned above. So why these reforms in particular? So I think that the task force expressed concerns about underrepresented jury pools. We don't have the data to conclusively answer questions about how diverse our jury pools are across our state right now. We're actually, I'm involved in a research project with Professor Frank Baumgardner at UNC, trying to answer those questions, but we know that there are a lot of concerns that are addressed by, that are raised by community members, attorneys, judges, and certainly defendants about whether or not our jury pools are actually representative in North Carolina. And we have a lack of data to allow us to answer those questions. I think there were great concerns about hardships and barriers facing working class jurors and primary caregivers. And of course, the importance of preventing convictions on the basis of bias. And again, the failure of the Batson framework to address jury discrimination. North Carolina, as you may know, is alone among the states in the Fourth Circuit in having no appellate reversals of criminal convictions on the basis of a finding of discrimination against a juror of color. And yet it's been 35 years since Batson was decided, which was supposed to offer greater protection against juror discrimination. And our appellate courts have heard well over 100 cases where challenges have been raised, Batson challenges, and yet we have never seen an appellate court recognize discrimination against a juror of color in North Carolina. This is all taking place along the backdrop of many studies that are showing that the use of peremptory strikes in North Carolina continues to be racialized. So in an article published in 2018, 3 professors at Wake Forest University Law School examined the use of peremptory strikes in all 100 counties in North Carolina. And you can see here some of their findings as to the rate at which Black jurors were struck relative to their white counterparts. And in the capital context, a very comprehensive study looking at capital trials between 1990 and 2010 concluded that Black jurors were struck at a rate of 2.5 times the rate of their white counterparts. And again, we don't have the ongoing data collection because so many jury trials, jury selection is not transcribed in many jury trials. So we can't answer all the questions that we'd like to about how juror formation occurs in North Carolina, but there's certainly cause for concern. And in fact, this is one thing that North Carolina has in common with Washington. Washington was one of the other states where appellate courts had never found a Batson violation against a juror of color. And what the Washington Supreme Court said, that alone does not prove that Batson is failing, but it is highly suggestive in light of all the other evidence that race discrimination persists in the exercise of peremptories. So I want to talk, and Justice Earls alluded to many of these, so I'll just quickly go through this, about the many different types of harm caused by juror discrimination in particular. Mr. Smith, I want to tell the story of Mr. Smith, who is a juror who was struck from a trial in Durham County. And he spoke about the experience afterwards. And what he said was, when he saw that the defendant, who in that case was a Black male, was going to get stuck being judged by middle-aged white women and middle-aged white men, as a Black man, it kind of hurt me that I didn't get picked. He also shared with the interviewer that when he arrived at the courthouse for jury service, doing his civic duty or responding to the summons, like many people, he was just looking for a way to get out of jury service. But as he saw one after the other of the other Black potential jurors struck from the pool, suddenly he felt very strongly that he did want to serve, and it was very damaging to go through the experience of being struck. These are some of the things that were found by the Equal Justice Initiative in their report on race in the jury, that the sting of mistreatment can linger for years when people are struck on the basis of race or another improper factor from jury service. These are statements. I'm just going to let them come up on the screen and you can read them as they do. These are statements that were made by Black potential jurors, all of whom were struck, just expressing their concerns about law enforcement, about over-policing, about their personal experiences or the experiences of loved ones with the criminal justice system. And as recently observed by the appellate court in California here, I think that many states and many who are concerned about jury discrimination are recognizing that, as you see here on the screen, it is time to reassess whether the law should permit the real life experiences of our Black citizens to be devalued in this way. At stake is nothing less than public confidence in the fairness of our system of justice. Obviously, as Justice Earls also described, jury discrimination harms defendants in real ways. And I'm going to ask you to put yourself in the shoes of Mr. Batson, the person who was at the heart of the case that started this entire framework. This is a picture of James Kirkland Batson. He lived then, and I believe still does, in Louisville. And he was arrested in 1984 for burglary. He did say he had been breaking into places, but he didn't do he didn't commit the crime that he was accused of in this case. And the prosecutor in the first case was Joe Gutman, who's actually pictured here many, many years after the case was resolved. And in the first trial, there was a hung jury, and the jury was, there were 11 white jurors and 1 Black juror. The 1 Black juror was the holdout, and she came and spoke to Mr. Batson afterwards and said she was convinced he didn't do it. In the second trial, the prosecutor, well, I'll let Mr. Batson himself tell you what took place, and please just get my attention somehow if you are not able to hear the sound. Oh, let's go back here. So this is a description. This is Mr. Batson speaking on the podcast More Perfect. The episode was Object Anyway, describing the scene in the courtroom. Sorry, guys. Let's see here.
What we want. Was he loyal white or was it the room as all of this is happening? And I'm like, that's completely, they struck all Blacks off the jury pool. It ain't right. I told my lawyer, I said, object to that. They, lawyer says, why would I object? James said, because it's not fair. He said, no, it's a long-standing rule. He's allowed to do that. And he can strike whoever he wants. Was he lawyer white or was he Black? He was white. Was the judge white or Black? He was white. And aside from those 4 people that had just been struck off the jury, everybody in the courtroom was white. So again, told my lawyer to object. And again, the lawyer says, he said, no, I told you, you can't object to this. So what do you mean you can't? You work for me. You do what I say. You just object anyway. I don't care. It's a long-standing rule. Object. And he did. And it all came behind that one objection. Yeah.
So I encourage you to seek out the remainder of the podcast. It tells the story of Batson and the difficulties applying the standard over the last 35 years. But I think it's really helpful and instructive to imagine the difficulty of seeing, especially after that first trial, of seeing what occurred in the second trial where Mr. Batson was convicted after all 4 Black potential jurors were struck from his jury. And I also want to just point out that I think we don't know, and it's very hard to quantify, how many people don't seek out their right to a trial by jury because of concerns that they will not be judged by a jury of their peers. There have been a number of cases in recent years where courts have had to review situations where officers may have been seeking to encourage or coerce a suspect to confess, and doing so by explaining that they will not, in fact, have a jury of their peers. This is an example of one such case. And so the harm is really, that harm is kind of unquantifiable, but very real. And of course, in Batson versus Kentucky, the court described that the harm from discriminatory jury selection extends beyond that inflicted on the defendant and the excluded jury to touch the entire community. So we know that when the process is perceived as unfair, the legitimacy of our system is at stake. There's a loss of public trust in the prosecutorial function. It may chill participation in the jury function by marginalized groups, create cynicism, and undermine the democratic check on the state's power, because as we know, the jury is really the voice of the people in matters of justice. So with that context and background, I am thrilled to bring City University of New York law professor Nina Chernoff into the discussion tonight. Let me stop sharing my screen and ask Professor Chernoff to unmute while I look for my introductions. Okay, thank you for your patience, everybody. Professor Chernoff, again, just very delighted to have you join the task force tonight. She is a professor of law at CUNY School of Law. Her research focuses on the jury, primarily the right to a jury selected from a fair cross-section of the community. Nina works with courts committed to assembling diverse jury pools. For example, she's currently a consultant to the New Jersey judiciary. And she also works with attorneys and community groups seeking to diversify their jury pools through advocacy or litigation. Nina's work was also featured on a great segment about jury diversity on Last Week Tonight with John Oliver. I'm going to ask Greg to put a link to that in the chat. It's about a 10-minute long segment and it is well worth watching. Please don't click on it now, stay with us and save it for later, but it is a really effective presentation of these issues that relies heavily on Nina's research. And Nina, we are so thrilled to invite you to speak to us about these issues tonight. So thank you for joining us.
Thank you.
And at first, I would just like to give you an opportunity to address what is the Fair Cross-Section Guarantee and why is it important?
Great. Well, the Fair Cross-Section Guarantee is a right. It's housed in the 6th Amendment of the Constitution, the federal Constitution, and in Article 1 of the North Carolina Constitution. And it gives a criminal defendant a right to a jury that's been selected from a fair cross-section of the community. The North Carolina Supreme Court has called it the right to a jury of your peers. The key point, and I want to highlight this because we've been talking about discrimination, a real problem of discrimination, is that the fair cross-section right in the 6th Amendment is entirely separate from the right to equal protection and the protection from discrimination that we get in the 14th Amendment. They're totally different constitutional provisions. And that matters because although the 14th Amendment is concerned with discrimination and whether discriminatory means were used to achieve an outcome like a verdict, the fair cross-section right is only concerned with the outcome. It's only concerned with the outcome of whether we have succeeded in assembling a pool of people who reflect the community or we have not. And it doesn't matter why we failed to do it. So this part of the Constitution is violated even if there is no discrimination involved, even if everyone is acting in good faith. And as for why it's important, I mean, some of those points have been made already about the harm that it does to the jurors who are excluded. And then there's the sort of fundamental reason that we have the jury, like why we bothered to revolt from England was we wanted to have the voice of the community interrupting the arm of the government and have the voice of community decide what justice looks like. So that's not just determined by people who are in the system who already have power, like judges and prosecutors. And the jury can't serve that function. They can't tell us what the community thinks of this situation if the group doesn't represent the community. But even if you leave the founding fathers and the revolution out of it, you just want to stay current with current statistics, there's a lot of current data about why having a diverse jury matters. And I prepared a couple slides to make this more clear. Just whenever I think about numbers, I want to see them just to be able to follow. So the data shows, and Emily, can you see my screen? Great. The data shows that the quality of deliberations is higher when we have a diverse group of people. I mean, that's to say, like, juries are better at doing the thing that they've gathered there to do, which is talk about and evaluate a case. So there were a series of studies that compared, just get to the compared the deliberations of 6-person all-white juries and compared that to the deliberations of juries that included 4 white people and 2 Black people. And what they found was that compared to the all-white juries, the diverse juries deliberated for longer, they discussed more case facts, they were less likely to make factual errors, and they were more likely to correct those errors when they did make them, and they were more likely to raise racial issues like racial profile. And what's particularly interesting about these studies is that it was really the behavior of white jurors that changed the most when they were in this diverse group. So this chart compares the conduct of white jurors on all white juries with the conduct of white jurors who are part of a diverse group. And you can see that the white jurors who were part of this diverse group themselves discussed more case facts, they made fewer factual errors, and they were more likely to raise race-related issues. So given this reality that deliberations are of higher quality when we have a diverse group of people engaged in that deliberation, it's not surprising that the verdicts those groups reach are less likely to be influenced by racial bias. And that's another reason why it's so important to have diverse juries, that we're less likely to get verdicts that are the product of bias rather than evidence. And the most thorough study of this phenomenon came from a study of 785 felony trials in Florida over a 10-year period. It was conducted by economists at Duke University. And this study looked at juries that were drawn from an all-white veneer. So veneer in this case being the group of about 27 people who were gathered at the courthouse from which individual trial juries would be selected. They compared their verdicts to the verdicts of juries that were selected from a veneer that included at least 1 Black person, sometimes only 1 Black person, but at least 1. And what they found over these 700 trials is that the juries that were selected from the all-white veneer convicted Black and white defendants at significantly different rates. They convicted only 66% of white defendants, but 81% of Black defendants. And the key is that this disparity, this gap in verdicts, almost disappeared when the juries were selected from a veneer that included even just 1 Black person. Then the conviction rates were more even. So, the diversity of the jury essentially cured the problem of racial bias that was infecting some of those verdicts. And then finally, diverse juries, as Emily mentioned, increase public confidence. And one example of this link, there's more data, I'll just share this one. This link between jury diversity and public confidence in the outcomes reached by that jury was a study of more than 300 jury eligible individuals. And it used a hypothetical of a Black defendant who was charged with shoplifting and asked the respondents to read about the trial and the verdict and then rate the verdict as fair or unfair. And they tested 4 different versions of this hypo. So in half of the hypos, the defendant was acquitted and half he was convicted. And in some of the hypos, the jury was described as being all white. And in some of the hypos, the jury was described as being racially mixed. And here's what they found. When the jury was racially mixed, people rated a conviction and an acquittal as equally fair. In other words, the mixed race, the diverse jury was seen as a fair enough process that any outcome was seen as fair. But when the jury was described as all white, respondents rated the conviction as not fair. So they didn't trust the outcome when the government prevailed. So I think I can stop my share here. There's more data along these lines, but I don't think we necessarily need it, because just ask yourself how you feel when you hear about a Black defendant who's on trial and facing an all-white jury. You know without the statistics that there's something wrong with that.
Thank you, Nina. So getting into the different specific recommendations made by the task force to try to address fair cross-section concerns. North Carolina, as you know, pulls the names for the juror list for each of our 100 counties from statewide lists of voters and statewide lists of drivers. And I'm wondering what you have seen elsewhere across the country that suggests that it may be important to expand to include more diverse lists. And if you could speak to that issue a little bit for us.
Sure. Well, it's obviously a critical issue because the jury system it's never going to get more diverse from than the source list. That's the starting point. So if those source lists don't represent the community, it's a way of guaranteeing that the jury pool will not represent the community. So why isn't it sufficient to just use the voter registration lists and the driver's license lists? There's a couple reasons. The main reason is that the people who are not on either one of those lists are disproportionately people of color. Research shows that communities of color, people in communities of color, are less likely to have a government-issued photo ID than are white people. And I'm going to try again, just as I said, whenever I have a number, I'm going to try and share screen. So the statistics show that although 5% of the white population lacks a government-issued photo ID, it's 13% of the Black population that lacks such an ID and 10% of the Hispanic population. And people with less income are also less likely to have one of these forms of ID, which is another way of saying being on one of these lists. So for people who annual income is less than 25,000, the 12% of that group lacks an ID, as compared to only 2% of the group that makes more than 150,000. So that's why a number of jurisdictions are using lists that are less tied to the government photo ID and are more tied to functions of regular life, like utility lists and taxpayer lists. And courts can also choose to use lists that are more connected to communities with less income. So the list of recipients of public benefits or people who have applied for unemployment benefits. But even if you just add I have a stat for this too, even if you say, okay, sticking with lists of government IDs with photos, even if you just add the list of people who have a non-driver's ID, you can get improvements. So for example, the state of Nebraska, like North Carolina, had been using voter registration lists and driver's licenses, and their jury pool underrepresented the Black community by 16%. So they decided to add the non-driver's ID cards because they realized that although Black people made up only 4% of licensed drivers in the state, they made up almost 18% of people with that non-driver ID. And after Nebraska added this other list, their underrepresentation of the Black community dropped from 16% to 1.8%. And the other reason—
Can I just clarify, you're saying that drop occurred and the only change they had made was adding in non-driver IDs?
Yes. Now, driver's licenses and non-driver's IDs can be kind of state specific. It sometimes matters, geography matters to whether more people have licenses or don't. So it's not that any jurisdiction that adds that list will see that exact drop, but you can look at the other lists that are potential additions, look at the racial makeup of those lists, and you can see which is the one that's going to add the most diversity or the most new names.
That's really helpful, Nina. Thank you. And I just want to point out that in our state, under our current statutes, while the statewide lists of drivers and voters are the starting point for our jury commissions may use other lists to supplement those that they deem to be reliable. So until we have any additional reforms that add in new lists at the state level, counties can go ahead through their county jury commissions and take steps to bring in additional lists that may include a more diverse, that may be more diverse in their composition.
Mm-hmm. And there's a lot of technical assistance that's available from the National Center for State Courts that has worked with many jurisdictions that have added lists and have lots of advice for the things that jury offices need to pay attention to, not necessarily the rest of us, about how that merger occurs, how duplicate names are removed, the sort of computer programming aspect of it.
That's really helpful, right? And I know they're a very important resource, as is NACDL and some other groups that are doing projects in this area. Can you explain the connection between the frequency with which we're updating our lists and the ultimate diversity of juror lists?
Yes, I mean, this is something that I think it's not necessarily intuitive. It's one of these funny things where what looks like kind of a boring administrative decision about how often to update the list has an impact on something as important as jury diversity. But it's true that the failure to regularly update the addresses on a jury list decreases the diversity of the jury pool. And that's because people who own their homes are less likely to move than people who rent. And because of systemic racism, structural racism, people of color are less likely to own their homes than our white people. So we have people of color moving at a higher rate than white people. That's true nationally, and it's true in North Carolina. When that happens, when someone's moved and the jury office has not updated their lists in enough time to get the new correct address, that jury summons is returned to the jury office as undeliverable by the Postal Service. And there's a lot of data that shows that undeliverables, those rates of undeliverable summons, are higher in communities of color. If we look at, home ownership rates in North Carolina, 75% of white non-Hispanic North Carolinians own their homes as compared to 47% of Black households. So we're just going to see mobility differences because of that home ownership sort of economic difference. So it makes a difference because let's say like North Carolina, the jurisdiction updates their list every year. They're potentially going to miss out on anyone who moves within that year. But if that window is shorter, if the jurisdiction updates every 3 months, they're only going to miss the people who move within that smaller window. And that makes a difference because those missing jurors are more likely to be jurors of color. And that's why places like National Center for State Courts recommends that if you're in an area where people are moving at higher rates, you should update your list more often, maybe quarterly. And I know at the state level, like New Mexico, they update their lists every 6 months. And Eastern District of Pennsylvania, which houses Philly, which has high poverty rates and residential mobility rates, they also update every 6 months explicitly to try and maintain the diversity of their pool.
Thank you, Professor Chernoff. That is super helpful. I want to keep talking to you about fair cross-section issues, but I also want to bring in our other distinguished guests tonight.
Yes, please.
I think we will return to these issues during our Q&A at the end. And so I'd next like to introduce the Honorable Judge Veronica Galvan. Judge Galvan has agreed to join us from Washington State, where they are 3 years into the GR 37 framework. She is the Chief Judge of the Melling Regional Justice Center. She's a 1994 University of Washington School of Law graduate. She has served as an assistant city attorney for the city of Seattle and also served the city of Federal Way in the same capacity. She took the bench in 2001, was appointed to a full-time judicial position as an administrative law judge in 2002. In 2007, Judge Galvan was appointed to the Des Moines Municipal Court, where she served with distinction, earning the was Exceptional Award from the Latino Bar Association of Washington. Governor Jay Inslee appointed Judge Galvan to the King County Superior Court in December of 2014. Judge Galvan implemented the only Spanish language court in the state of Washington, granting hundreds of litigants the opportunity to address the court directly in Spanish. She was recognized by her alma mater with the Dean's Leadership Award in 2015. In 2016, she was recognized as a Woman of the Year by the Center for Women and Democracy. In 2018, she earned the Vanguard Award from the Washington Women Lawyers, and in 2019, she was honored with the Joaquin Avila Award by Seattle University School of Law. In 2021, Judge Galvan was appointed as co-chair of the Washington State Minority and Justice Commission. In addition to her judicial duties, Judge Galvan is currently the past dean of the Washington State Judicial College, where she has taught several courses, most recently, Emerging Through Bias Towards a More Fair and Equitable Courtroom. I'm sure all of us here tonight would like to take that class with you. Judge Galvan has also been an adjunct instructor at Seattle University School of Law and has lectured extensively at legal education programs across the country. And we are so thrilled to have her with us tonight to talk about GR 37 in Washington. Judge Galvan, welcome. Thank you for being with us tonight.
Thank you very much for having me.
So for starters, I'm wondering if you could just tell us about why the Washington Supreme Court decided to adopt General Rule 37?
Well, I think it's based upon a lot of things that have already been stated. We recognize that the framework set up by Batson was insufficient for the purpose that we really wanted to achieve, which was to eliminate the unfair exclusion of jurors based on race or ethnicity. And we focused on race, not because there aren't other forms of discrimination, but because we found that when we intersect and when there's these intersections, that race really kind of hovers above all of them. So yes, there's discrimination because you're female, there's discrimination because you may be not physically able, but when you overlay that with race really undercuts so much of this. And so recognizing that, and I think Batson recognized that too, GR 37 focused specifically on addressing the issues that we had seen with the Batson framework. So GR 37's scope is broad. It applies to all jury trials, civil and criminal. The objection to any peremptory challenge may be brought by a party, or frankly, the court has an affirmative duty, if they see it, to bring it up themselves, which I think is really also a powerful tool because it doesn't just put the onus on the parties.
And I wonder if you could talk a little bit about what concerns, if any, lawyers and judges had about GR 37 before it was implemented. What was the kind of, if you could take the temperature of the different parties that were going to be having to adjust to this new framework, what were the concerns you were hearing from your colleagues or from attorneys about how GR 37 might operate?
People felt that it was really a big ask. They felt that, the rule itself, unlike Batson, does not require a showing of purposeful discrimination. I think that what the Supreme Court in Washington did is recognize that so much of the peremptory strikes are not the result of explicit or purposeful discrimination, but a lot of it from that gut feeling that we call, right? We always use peremptories as we just don't feel like this person's going to be fair. And then under the Batson framework, you had to establish purposeful discrimination. Under GR 37, you don't, because we recognize that a lot of the discrimination that occurs is not malintentioned or ill-intended or intentional at all. It is unconscious and implicit. So recognizing that, we had to have the people who practice in our courts, our judges, all actors in this court system, understand what that meant. And I think the initial reaction, frankly, was fear. That now, instead of just taking this class on diversity and congratulating yourself because you've learned these things, you now had to have a substantive understanding of how we got here, how our legal system has created some of these issues. You talked, for example, about jury lists, and some of the first things that came through me when we talk about homeownership, when we talk about stability, redlining, which was allowed by courts. There are several decisions that talk about allowing for things such as this. I often say that courts have touched every single agency, have touched every single institution, and we have lent an imprimatur of legitimacy to some of the policies and practices that have led to some racist results. And jury exclusion is, again, one of those policies and practices that we've just taken as such. So I think the change of what was going to be required of individuals and the knowledge that they were going to have to obtain to be able to engage in the nuances of these conversations with each other, with the jurors, and for judicial officers to be able to manage all of that. Because some of these conversations can be and have been extraordinarily painful and traumatic for some of the people involved in them. And so I think that initial, how are we going to do it, that practical implementation was one that was very difficult to overcome.
That's really helpful to know. And I know that from what I've heard, it was implemented almost immediately after its adoption. And so there wasn't necessarily time to do the sort of training and preparation that might have been helpful in preparing to have those kinds of conversations. Are you seeing more, are people raising more objections under GR 37 than they were raising Batson challenges in your courtroom?
I would say yes. And I would also say that there's less attempts to preempt jurors of color. Because I think with the understanding of what the court's role, duties, and obligations are, as well as what your obligations are to establish a reason that's beyond race neutral. And I'll give you an example. One of the big things in Batson is you make a prima facie purposeful discrimination. Then the other party who's trying to exercise the challenge essentially has to come up with a race neutral reason. And you think about so many of the reasons that have been deemed as okay to be race neutral. The state Supreme Court of Washington, recognizing that, specifically said that things such as having prior contact with law enforcement officers, expressing a distrust of law enforcement officers, or a belief that law enforcement officers engage in racial profiling, having a close relationship with people who have been stopped, arrested, or convicted of a crime, living in a high crime neighborhood, having a child outside of marriage, receiving state benefits, and not being a native English speaker are presumptively invalid as a challenge. And I want you to think about that, because all of those reasons were found at one point or another to be, in many separate instances, race neutral explanations that would allow for the striking of a juror of color. The Supreme Court of Washington also indicated that the determination of whether race or ethnicity was used as part of the challenge is determined on an objective observer standard. And they even define what an objective observer is, which I think is really important, because according to our rule, for purposes of this rule, an objective observer is aware that implicit, institutional, and unconscious biases, in addition to purposeful discrimination, have resulted in the unfair exclusion of potential jurors in Washington state. That is an extraordinary, powerful statement, in my opinion, because of what it requires substantively for individuals to practice law in our state. This, again, is substantive law that you need to be familiar with, that you need to be able to address, and you need to be able to recite and practice, which I think has been pretty incredible. So judges have developed tools, and it did start pretty immediate. I remember the week after this rule, I had a case, and I used juror questionnaires to develop the ability to discuss these issues fully and fairly. Some of the issues that are discussed are uncomfortable, again, traumatic. The parties have raised them with jurors, but they have led to extraordinarily robust and interesting discussions. I agree anecdotally what Professor Chernoff and what you showed with regards to diverse juries and the quality of the verdicts. We see that a lot more. We see a lot more discussion. We see them taking longer. And I think our jurors themselves are also now becoming aware of these issues. So even if the attorneys hadn't raised them, our jurors, our veneers, were starting to raise these issues. The Western District of Washington, understanding the importance of addressing issues of bias, came out with a video for jurors in which they talked about bias. And that's a video that's presented to the jurors before they start to serve. King County made its own as well. So we are openly addressing some of these issues, discussing them fully in an effort to ensure that a fair cross-section of our community is able to serve, and that we have a representative panel.
That's fascinating, Judge Galvan. It sounds like what I'm hearing you say is you're seeing more diverse juries. You're seeing less, from what you observe, juror discrimination. you're seeing more robust conversations openly and honestly, even sometimes traumatically, about race and bias. And what the research that I'm familiar with suggests that when we make those issues salient and bring them to the forefront of a conversation, that can actually help decrease the influence of implicit bias on decision making. So I'm not sure if that was an intentional, if it was one of the intentional stated purposes of GR 37 to encourage those kinds of forthright discussions of race and bias and racism in the courtroom, but it sounds like it's having that effect.
Well, I think it has to have that effect if you're going to implement the rule, because these issues need to be discussed fully and fairly. Now, obviously, if you're going to challenge somebody for being a juror or for being unfair, you're going to have to explore that. And you're going to have to explore it within a context of understanding issues such as how policing has historically occurred in our communities. You're going to have to understand that within the exploration of issues of how things like redlining have impacted our communities, how these historical happenings and these present happenings continue to impact communities of color. You cannot deny those facts. And as you discuss them within this context, you have to really question, what does a racially neutral explanation constitute if you know that history? Is it truly racially neutral? Those nuances are hard to grasp, but they are important as we engage in these discussions. In terms of juror diversity, again, it's only as diverse as our source list. And I think that we have the same challenges as other states, although we do utilize other mechanisms to source our jurors here in King County, but we do have those same challenges. And so we are continuously trying to make sure that we have a diverse veneer so that we can have more diverse panels. But what I'm finding is, for those communities of color who are called to serve within the panels are more diverse, comparatively speaking, with the veneer, but our veneer is still not as diverse and still not as representative as it should be. That's a separate issue that we're also trying to address.
Sure. I understand. What advice do you have for states that are considering reforms similar to GR 37, given that you are serving as a judge in the state that was first to adopt such reforms? Is there anything that you think that states like North Carolina that might have, where there might be court actors with an interest in seeing this sort of reform? What advice do you have for those of us in North Carolina and elsewhere who are in that position?
The advice I have is don't be afraid of it. I think that, especially institutions such as our courts, we're an institution that turns to its past to inform its present, and it makes decisions about the future based upon that. With that in mind, we cannot ignore historically what has happened. Now, many people say, a willingness to look at ourselves tells the public that they shouldn't have confidence in the judiciary. And I believe quite the opposite. I think the legitimacy of the work that we do rests on our ability as an institution to acknowledge when we may have erred in dispensing justice. And it is not a constant willingness to look at this that is the issue. It is the willingness, when the circumstances call for it, to have the courage to revisit, to reflect, to recognize, and to reconcile that our institutions are as imperfect as the people who comprise them. And that it is the practice of our principles, ultimately, that this, I think, calls for. So don't be afraid of that. This is what we are called to do as a branch of government. And I think people who practice law should understand that what fairness and what justice look like. And that individuals who comprise your community, who serve in your community, should be allowed to be part of that community and participate in what is the only time that you are ever called for civil service. I mean, we have a military draft, but in civil service, the only time you're called to serve as a member of your community is this, as a juror. And I agree with Professor Chernoff completely. It's one of the most important aspects of our democracy and of civil society. So embrace it, be comfortable getting uncomfortable, and have several education programs to educate your actors in your legal system, because they're going to need that foundation to start addressing these issues.
Absolutely. Thank you so much, Galvan, Judge Galvan. That was really helpful and really eloquently put, and a perfect lead in to the next topic that I'd like to discuss with Judge Weeks about educating court actors on implicit bias and other related issues. So at this point, I want to officially welcome and introduce the Honorable Judge Gregory Weeks to our event tonight. We're so pleased that you're able to be with us tonight, Judge. Judge Weeks is a retired senior resident Superior Court judge from the 12th Judicial District, 4th Judicial Division. We keep it extra complicated in North Carolina. And this is in Fayetteville, for those of you joining us from outside of the state. He is was faculty at the National College of Criminal Defense Lawyers for many years, also at the National Institute of Trial Advocacy. He has trained lawyers in South Africa through the National Institute of Trial Advocacy, the United States South African Leadership Exchange Program, and the Black Lawyers Association of South Africa. He has won the Outstanding Trial Judge Award from the North Carolina Advocates for Justice in several different years. The Centennial Award from the North Carolina State Bar Association. He was conferred the Order of the Longleaf Pine for service to the state by Governor Beverly Perdue. He received the James Williams Award for Racial Justice and is on the Board of Directors of the Sentencing Project. I could spend the remainder of our time tonight detailing his many, many accomplishments, but I will just wrap up by saying that every time I get to partner with Judge Weeks on any kind of project, it is a just true honor and delight. And I'm very excited to have you here tonight, Judge Weeks, to talk about educating court actors and jurors on implicit bias. And I'd like to start, I know that as a judge, you developed your own, you were sort of ahead of the game, you developed your own jury instructions on implicit bias, probably before any state had adopted pattern jury instructions on the subject. You had developed your own. And before hearing about those in particular, I just want to ask for you to speak to why you think it's important to have those conversations with jurors and to offer specific instructions on the topic of implicit bias.
Thank you so much for having me. This is such an important subject, and I'm thrilled to be a part of it. Actually, the instructions that I developed shortly after I went on the bench were an offshoot of what I did during jury selections as a public defender and in private practice. It's been mentioned a couple of times, but I think it's worth repeating. One of the difficulties that's inherent in making meaningful change has been the unwillingness to acknowledge the truth of our past, specifically as it relates to the criminal justice system. But the reality of it is that there is no sector of life in this country that's not impacted in one way or another, whether it be healthcare, education, housing was mentioned by Judge Galvan. So the criminal justice system is essentially no different. In fact, it may be, because of the history related to that, coming out of Reconstruction, going from outright slavery to convict slavery, and how the criminal justice system was used to implement that, probably makes it more egregious. When I incorporated that into my jury selection approach, initially I got a lot of negative feedback from judges. Had a lot of conversations with judges in chambers, off the records, after trials, explaining why I was doing what I was doing and what I hope to accomplish. So when I became a judge, I had some materials that I could work with to develop, incorporating that into the preliminary instructions to the jury that takes place prior to every trial. Initially, as I shared with you in our group, the implicit bias program that we worked together on, I felt it was best to try to address it in a non-confrontational way. And I used a sports metaphor. For those throughout the country, I'm sure most of you are familiar with the competition between Duke University and UNC Chapel Hill. So that's what I started with. I would not be a good person to serve as a referee at the ACC championship where Carolina was playing against Duke. The score is tied. Carolina's got the ball, driving on the basket. There was contact just as the clock was running down, and I had to make a determination. Did the Duke defender foul, or did the Carolina ball player charge? I have a bias. And that was the lead-in to a discussion about how bias affects all of us one way or another. That's a word that folks kind of cringe and tighten up when they hear it. So I felt more comfortable approaching it in the context of something that was safer and working our way up. Interestingly, another factor that led me to do it, and I want to be absolutely candid about this, trial lawyers were not doing it. Because if you practice in a jurisdiction where you're dealing with the same prosecutors day in and day out, you don't want to offend that. And if you know that you've got trial judges, and our trial judges rotate in, but their reputation precedes them, that are not comfortable raising issues such as race, then you've got to figure out a way to do it that is going to give you minimal heat, but more importantly, an opportunity to start the conversation with all of the parties involved. I was very disappointed that our trial bench, by and large, and I'm fairly confident that's true across the board, are not anxious to create angst with the prosecutors they have to deal with and all of the other players in the system. But it's something that has to be addressed to make meaningful change. We're seeing some change now, but here we are 140 years past Stroud versus West Virginia. And we're still grappling with the same issues. So I'm happy to be a part of a conversation that hopefully will lead to more widespread change in addressing issues that relate to race in the criminal justice system.
Thank you, Judge Weeks. And you touched upon so many concerning patterns that you saw as a judge among, unwillingness of the bar to have these conversations and resistance from other judges. How would jurors respond when you would open up these questions or give these instructions? Did you feel as though, certainly you were looking for, and I'm sure you found a non-confrontational way to bring up the subject of bias, but what was your experience as to the impact that it had when you would raise the subject of implicit bias and bias more broadly, explicit and implicit bias with jurors?
My goal was to get that first hand raise. And I would stroke that juror by telling them how important it was that folks have the courage to speak honestly and openly about their feelings, understanding that it's difficult to do that. You want to communicate a message to all the other prospective jurors, both in the box and in the audience. This is okay. In fact, it's absolutely necessary. And once you do that and get that first juror to raise his or her hand, you follow up with some additional questions, but you make it abundantly clear that this is the appropriate and necessarily right thing to do. And gradually you'll see one or two other hands start going up. You've given permission for those jurors to come forward with their honest views and attitudes.
Right, and you've set the stage that there is no right answer, recognizing that this is a group of strangers that is, called to this very kind of solemn duty. And they are being asked to talk about some sensitive issues and it's important, I think, I hear you saying, to set a tone where whatever their true opinions are welcome, so that you can get to the bottom of how they actually think, and ensure that you don't have someone serving on a trial who is going to be biased against the person that they are being called to sit in judgment of. I know you're familiar with, I don't know that these materials were available when you were still on the bench, but the video that Judge Galvan was speaking about that was produced for the Western District of Washington, addressing implicit bias with jurors. You and I and several other people have been working on a North Carolina version of an implicit bias video for jurors. Talk about how you think a tool like that can and should be used by judges and attorneys in North Carolina in jury selection.
You're talking about the instruction in general?
I'm talking about the video as something that, as a supplement to the instruction, and recognizing that my understanding is that there's no one tool that's going to be a silver bullet, but the more opportunities there are to address these issues, the more, the more seriously they will be taken, and the more you kind of encourage people to open up and actually engage in the hard conversations that need to be had.
I think it's an important tool because at least they are given some general information about the subject, and the fact that it's likely to be delved into as a part of the process gives them an opportunity to think about it. I'm absolutely confident that there's still some folks who are uncomfortable and bring that level of discomfort into the courtroom and into the process, but then it's up to the judge to build upon what was said or what was portrayed in that film and explain to some folks who may have additional concerns why it's necessary and why it's helpful and important. And again, if you get the first juror to raise his or her hand, once you've done that and you communicate about their concerns, you'll see additional hands go up. Everybody's not going to raise their hand, but they're paying attention. And more importantly, you're not just talking to the folks in the box and the prospective jurors in the office, you're communicating a message to the lawyers as well.
Do you think that court actors in North Carolina currently have access to enough opportunities, such as those that Judge Galvan was describing, judicial education and legal education about implicit bias, systemic racism, the history of juror discrimination? Do you think that the bench and the bar are in need of greater resources and opportunities to become literate in that history and in that reality and proficient in addressing it?
Absolutely. Up until relatively recently, there was almost no real training or opportunity to have meaningful discussion about the subject matter. That's changed to some degree in the past 4 or 5 years. There's still a lot of reluctance out there. You can tell folks convey a whole lot by their body language. And when you start raising the issue and you see crossed arms and folks leaning back in their chairs, you understand what it is that you're dealing with there. So I'm happy that the fact that we're having these opportunities to provide more training, because I think the training is the key. By way of example, I recently went through Racial Equity Institute training shortly after I left the bench, became a community monitor at UNC in the various schools. The goal of that training is to bring that information back to your community, to connect with people from diverse backgrounds in the community and address issues among issues similar to what we're talking about. We recently dealt with a bail issue in our county, but the real key is the information. You can cross the threshold into kindergarten or preschool, and from that through high school and beyond college. What you get in our country, and I don't mean to be disrespectful, but it's true. You get his story, you don't get history. And until you know the truth about our country and how issues of race, gender, for those of us who are trained in the law, Declaration of Independence, we hold these truths to be self-evident that all men, no women, Constitution of the United States, 3/5 of a person, it's woven that deeply into the fabric of our nation. And that we're not willing to understand that and acknowledge it and do what we can do to be more inclusive for all of our citizens, then we'll continue to have another 20 or 30 years where there'll be another iteration of Batson or one of his progeny down the road. But in terms of meaningful change, not much will have really happened. So my goal is to see that stuff really happens.
Judge, that's really helpful. And I think that it's, again, always so key to bring us back to that history and make sure that everybody that's engaging on this is aware of that history. Everyone, not just people involved in the jury and justice systems. I have one final question for you before I bring all of our panelists back into our final Q&A section of tonight's program. And that is, for those of you who are familiar with Professor Liz Semmel's report, Whitewashing the Jury Box, much of what's contained in that report is an examination of manuals used to train prosecutors in selecting juries. And they are sometimes nakedly discriminatory, sometimes just heavy on the pretext. But I think that we all know that, we have some evidence in North Carolina of historical training materials and trainings for prosecutors that were designed to really evade protections offered by Batson by presenting acceptable race-neutral reasons that are really just veiled attempts at kind of concealing discrimination. And I think that as we look at that recommendation that the task force has put out about implicit bias training for all court actors, we have to think about the kind of training that goes into jury selection for everyone who's involved in it, and in particular prosecutors. And I know that both you and I have been involved in efforts to train prosecutors on jury selection to kind of try to give birth to a new era of training that is about embracing inclusive juries rather than, using these old stock juror profiles that have, both intentional and implicit bias baked into them. I wonder if you could just speak briefly to the efforts that you're engaged in, if you're comfortable doing so, or just your thoughts more broadly about what we need to see, not just in the broad education around our nation's history and on bias, but specifically skills-based training for attorneys around jury selection that is non-discriminatory, what you think that looks like and where you think we could be headed with that.
Some of my former colleagues, you indicated I was still on the Sentencing Project Board. I ended that last year. But Cynthia Jones, Professor Jones at American University, Angela Davis at American University, both former PDS folks from the DC area, are Professor Jones, to a greater degree than many others, have been involved in providing that kind of training. There's some resource material that you might want to access on the Sentencing Project website. I'm trying to recall specifically, I think there was some material that was submitted a couple of years ago related to the Washington state preliminary stuff and several other jurisdictions that were making meaningful change in the systems that exist. I think from my perspective, though, the best education are meetings like this, hopefully in person as opposed to Zoom, with folks from all aspects of the system talking about why there is a need in terms of the credibility and the faith that folks in our community might have in our system if there was a greater effort on the part of all of the players to do what we're called upon to do. Apply the law fairly and independently against everybody, regardless of what you look like, where you come from, or what your economic circumstances are. That's ultimately what the goal is all about.
Absolutely, Judge. Thank you so much for those comments and for sharing your perspective on these recommendations and on the ultimate goal, as you put it so eloquently just then. I know that we've seen a couple questions come in. One of the most recent comments was encouragement to participants tonight to take the implicit association test that is free and online, hosted by Harvard. There's a link to it in the chat. Thank you for that. I try to take it every couple years, and you can take it on different subjects. It's extremely informative and helpful. So there was a question during, just backing up to the conversation we were having with Professor Chernoff about how to ensure that juror lists are inclusive of people with disabilities as well. Most people with disabilities are capable of serving on juries. However, many people with disabilities do not drive. So if you're in a state like North Carolina, where our juror lists are comprised of voters and drivers, that may contribute to underrepresentation of people with disabilities. Have you seen any efforts to ensure that community members with disabilities are included in a representative fashion on jury lists?
I haven't seen any efforts that focus on that community, but certainly every state has to evaluate what are the source lists that are going to add the most number of names, the most new names. And it really depends on the jurisdiction. Like Alaska uses the list of people who get a subsidy from the pipeline, which is everyone in Alaska. So they have a great list there. Well, on paper anyway. I don't know about how it's being implemented. So in each jurisdiction, this is another reason why demographic data is so key, needs to evaluate who's missing from the current source list and how that can be augmented. Because if you simply add another list that has the same group of people that similarly disproportionately represents wealthy white people, it's not going to add value, and in fact could be a problem because it's more likely that those names would be duplicated, and so certain populations would be called more frequently. So I think that's the most I can say to that. I mean, I think although the legal standard doesn't ask us what does the jury pool look like in relation to the pool of people who are being prosecuted, if I could rewrite the legal standard, I would make that a part of it. That the legal standard asks us, what does the jury pool look like as compared to the community, which is a fundamental question. And it's we're failing to make those two match up. I'm also interested in what does the jury population look like as compared to the population of criminal defendants. And there where we see such deep racial and ethnic disparities, to me that lifts up the racial and ethnic disparities as the most acute. But we know even outside of the jury system that the more diversity we have, the better decisions we reach. I didn't include it, but there's evidence that demonstrates that in, say, business context. So it's not just about race and ethnicity, but that's been the focus. The one other thing I'd add, and this is just really called up by Judge Galvan's and Judge Weeks' powerful comments about the history, is this is why it's not enough for a jury system to say, well, we use a list that has a lot of people on it. We send out a summons, some people get it, some people don't. We pay this amount of money and some people can afford it and some people can't. Those are race neutral decisions, but they are playing out in deeply, in a context that's the product of deliberate racism. So to say that these are race neutral approaches that fail to take account of the ways we've structured the ability of people to respond to those summons or accept that jury pay, so I would just add that not only do we need to take account of that history when thinking about implicit bias and strikes, but that systems need to think about that when evaluating how fully they are complying with their affirmative duty to bring in a representative group, that it's not enough just to have race neutral jury summonsing policies.
Right, and I so appreciate that point, Nina, because I think that this has been well made in some of the scholarship and literature about, I'm thinking of Paula Hannaford-Agore's article about thinking about systematic negligence and thinking about why, the fair cross-section guarantee has built in it the requirement to find a flaw in the process. But how we think about what that means, a flaw in the process. Is it a flaw in the process to not account for the deeply racialized context in which these summons are being sent out, right? And so certainly we could have a whole other panel discussion on if you were to rewrite the fair cross-section guarantee and what it would include, how it may look different. And I think that some of those questions are actually still up for grabs in our courts because it's so rare that we get a fair cross-section decision from the US Supreme Court and even from our state Supreme Courts, that I think it's still worth encouraging attorneys to push on those issues, on expanding how the courts interpret the fair cross-section guarantee, as well as working with courts who voluntarily recognize that these problems are actually on the courts to work out and not on individual jurors. And I think that in particular, your point about defendants versus jurors, I just wanted to mention that, again, the study that I am working on with Professor Frank Baumgartner at UNC will also be looking at the zip codes and addresses of defendants in various counties versus those of seated jurors, and doing mapping to really see visually are folks getting a jury of their peers. Because certainly anecdotally, when I speak to both people who've been charged with crimes and attorneys who represent them, I'm thinking of one particular attorney who said to me once she learned that juror lists were comprised of voters and drivers, well, most of my clients are neither, so that excludes most of the people that I represent right off the bat. If we think of jury formation as a funnel, and it's sort of, if you don't have an inclusive representative pool at the beginning, you're certainly not going to have that at the end of the process. And as I've learned from you, Nina, I think that the research, and you can speak to this a little bit more than I can, but the research shows that the same strategies that increase juror diversity also increase juror yield, right? So I hear from judges around North Carolina that they're concerned about juror diversity, the diversity of the pools, but they're also just concerned about getting enough people in the doors, especially during the pandemic, where that was a real concern around people showing up in response to summons, to their jury summons. Can you speak to this finding that researchers have, I think, in a number of studies, determined that the same types of efforts that increased jury yield also increased juror diversity? I wonder if you could just speak to that a little bit.
Yeah, that's one of the great opportunities in this particular area of reform, is that the interests of a lot of different constituents dovetail. And so the courts that are short on money and short on willing jurors are likely also short on diversity. So both writ large, if you increase jury yield, the number of people who come into the courthouse for the number of summonses that are sent out, it increases diversity. But also each of the specific reforms that I mentioned and others have a kind of two-for effect. So for example, I mentioned updating addresses. That is more likely to bring in a more diverse group. It also saves money, because if you're sending your summons to the accurate address instead of the inaccurate one, you save on all those wasted mailings. So it's more efficient, it takes less court time, and it saves money. And so a lot of the reforms are like that. They have that double benefit of increased efficiency because they're bringing in more people with less sort of squandered effort, and they increase diversity.
Thank you, Nina. I have one final question for Judge Galvan before we close tonight. And I just wanted to ask whether or not you have seen, so you mentioned that under GR 37, judges are expected to raise the issue where they observe it, even if attorneys are not concerned that a peremptory strike was improper. I would just like to know if you see that, if you find yourself doing that, and if you hear from your colleagues that that is happening. And I'm just so fascinated by what I imagine must be for many judges a very rapid education in how to kind of manage this new framework and be the sort of presiding judge over the requirement to be an observer, to be that objective observer who is aware of implicit bias and systemic racism. Can you speak to just how that plays out in your courts? I just want to give you the last word so that we can imagine, because I think so many of those conversations don't happen, even when they are necessary to ensuring that we are able to administer fair and impartial justice. I wonder if you could just leave us with a final reflection on how that's playing out in your courtroom or across Washington from what you've heard.
Well, I think initially judges, and for a good reason, are very reticent to step in when you're watching the parties engage in the trial. But now we have this rule that actually requires you to affirmatively engage in order to protect the integrity of the process. And I think that was definitely a different manner in which judges were not accustomed to engaging the parties or certainly the jurors. So I think that the expectation is certainly different. And that there was, again, a miasma of fear when this originally came forward. I myself, because I've studied these issues, I teach on these issues, didn't necessarily feel uncomfortable with the subject matter, but I cannot say that about all of my colleagues. And I think some of my colleagues who really, truly were afraid to even engage in these topics. They felt that they did not have the tools to do so. They felt that it would make them seem one way or another, that they might be viewed as biased, or and they didn't know how to manage the expectations, the emotions. As I said earlier, the trauma. One of the first times I engaged in this, I had a woman. I had a gentleman who happened to be white, who discussed some issues outside the presence of the other jurors about how he felt about specific groups of people and how he was raised. And as he's talking about it, he goes, "But I'm not racist." And I said, "Sir, this isn't a basis for us to judge your humanity, your views or your perspectives. What we need to know is, in all honesty, are these views or these perspectives going to interfere with your ability to evaluate the evidence?" But it was like you could almost see the light bulb going off in his head as he's speaking. And in the same case, I had an African-American woman who, again, outside the presence of the other jurors, was questions about some of these issues. And her response was, "There is no way I can be a juror with these racist people." She goes, "There's no way I can sit in a closed room with them." And she was clearly upset, crying. This was a traumatic experience for her, having to essentially think about her life experiences. So all of these things are extraordinarily emotional. They're extraordinarily real, the perspectives, but we have to value the perspectives of the experiences that people bring to the table. Diversity is important because of that, because the more perspectives you have, the more lenses you have on a problem, the better product that you get. That's why it's important. And it requires people to, in a civil way, all look at the same evidence and then just filter that through their lenses and come up with a decision. I think it's fascinating. And I wish that people were obligated to do that in everything that they decide or as they develop opinions, based upon facts, based upon evidence, looking at nuances and understanding that not everything is black and white, but several shades of gray. So I think with the education and with coming up with practical ways to handle some of these issues, our judges it's now part of our culture. It's amazing how quickly that it just becomes part of it. I do note that initially civil attorneys, for some reason, thought it didn't apply to their cases. And that was a hard reality because I don't think that they were as used to Batson issues as we were perhaps in the criminal arena, but it applies to all jury trials. And so it's been quite interesting to see the civil bar have to weigh some of these heady issues in ways that perhaps they didn't because of the nature of their practice. Not that it didn't exist, but it wasn't as prevalent or didn't overlay things to the extent that it does in the criminal system.
Thank you so much, Judge Galvan. That's incredibly well put and helpful reflections for those of us in North Carolina. I am often surprised to learn from civil attorneys that they don't know that Batson applies in their cases. It just doesn't come up that much, nearly as much as it does in North Carolina. And I wanted to point out that my understanding is that while there were no successful Batson challenges under the old Batson framework in Washington, there have already been some under GR 37. And so I know that it is changing the game in a big way. And I think that your reflections point to the need both for literacy in racial equity and the history of our country and jury discrimination and implicit bias, as well as to education on trauma-informed courtrooms. So I really appreciate what you have shared with us tonight. It's super helpful in a state where we have a similar Batson record to Washington and are looking at similar reforms. So on behalf of the task force, I want to thank everyone for joining us tonight on Zoom and on YouTube. I want to especially thank our distinguished guests, Professor Chernoff, Judge Galvan, Judge Weeks. It's been very enlightening to speak with you about these issues, and we will continue to seek your guidance as we move forward in pursuing these reforms as a task force. Thank you so much for being here tonight. Thank you, Justice Earls, for welcoming us. And I hope you all have a good evening.